It's Sunday evening, and this is the Modise Network. Two top lawyers, Advocate Dumisa Ntsebeza and Advocate Dali Mpofu, join us to talk about the role of the rule of law in a constitutional democracy such as ours. Do we fully appreciate what the law prescribes as rights to us as citizens? Does our society appreciate the independence of the judiciary? Why do we always have to run to the courts to force government to perform its duties? And thank you so much for joining us this evening. I'm Modise. The South African courts, especially the High Courts and Constitutional Court, have had to intervene in various political matters involving the government and its institutions. Over the years, many people have wondered why non-governmental organizations, opposition parties, Chapter 9 institutions run to the courts to make rulings on the government's obligations. Is the judiciary all too powerful and overreaching? Which is, of course, what some politicians have been complaining about. And this evening, I'm joined on the couch by two top lawyers who can perhaps help answer that question. And both of them have participated in various matters where the rule of law was being questioned or tested. Let me start with the chairperson of the EFF, Advocate Dali Mpofu, as well as Advocate Dumisa Ntsebeza, senior counsel, I must say. And gentlemen, a pleasure to have you with us here. I was talking to one of my colleagues about how to refer to lawyers, you see, because advocate, senior counsel, and this and the other. But one thing I've observed is you refer to each other when you are in court as my learned friend here. But let me tell you something. We refer to you in the streets as Majiani. Yeah. Which one is the appropriate one?
Majiani, what's that?
He will know.
Majiani is the one who changes the story. Oh, it's better.
You get away scot-free.
Exactly, yes. Yeah.
But be that as it may, the law has been, the courts in particular have had to make so many rulings that people feel should be in the political domain. And the cases that come to mind are those that enforce the socio-economic rights in particular. I'm thinking of the Grootboom case, for instance, the Mike Komape case, the textbook case, and so forth. Why do you think that we've got to a point where the courts have got to say what government should do? Because on the other hand, the view is that it should be left to government, after all, to implement those. But let me start with you, Advocate.
Well, I suppose the courts have had, in terms of the constitutions, even though they are a third tier of government, as you know, there are three tiers of government. There's the legislature, which makes the laws, and there's the executive that implements the laws, and then there's the judiciary, which plays an oversight role. And especially in constitutional democracy, it makes sure that people live within the prescripts of the Constitution. But one would have loved in a democracy to see a situation where there is less rushing to the courts by individuals. And that would happen if those who wield public power, for instance, wield it in a manner that is commensurate or that is in line with the Constitution, with the rule of law. In other words, I mean, the rule of law simply means no one is above the law. So if you are president of the country, there is the law in various acts, what you can or cannot do in terms of the legislation, and then of course there's the Constitution, and the Constitution delineates what a president or can do in terms of the law. So I think in a short way, the short answer is the courts should be used sparingly to fight for people's rights.
But then you also, it seems to me that you need a vibrant civil society And it is as a result thereof that we've seen so many cases being taken to the courts, that if we did not have that vibrant civil society organizations, then we would not have seen some of the cases being taken to court. And it also says a lot about the performance of the government. What do you think, Advocate Mpofu?
No, that's very true. I think the starting point, Tim, is that ours is a constitutional democracy. And we say that we have a justiciable Bill of Rights. Now, what that means is that the supreme law of the country is the Constitution. So any law that you and I can pass about this and the other must be subservient to the Constitution. Mm-hmm. Now, it is as it should be that should a dispute then arise between you and me as to whether it was your right or my right to have this bottle of water and so on, then the institution to resolve that is the court. So that's the system as it should be. So that the court, otherwise, if you take my bottle of water and I think it's yours, you think it's mine, then I must just hit you and take my water. Yeah. So if there's no institution that's going to determine whose bottle of water it is, which is the courts, then people would resort to self-help, to violence, to all sorts of other, because disputes will always be there.
Now, I find it interesting, though, that we've referred to the NGOs, right, and the fact that they're on there. That the Chapter 9 institutions have had to do exactly the same themselves, even though they've been created by the Constitution itself. Let's take a look at what the Public Protector had to say on one particular matter.
I think it's time people in government reflected and posed after a decision has been made by the Public Protector or the courts. Increasingly, people just decide to take a matter on review within minutes of a decision being made, and that gives me a sense that people do not apply their minds. I would think that this kind of decision by a court is trying to say to people, please pause, please think about implications for good governance and implications for the use of taxpayers' monies, which should be building hospitals, we should be providing medicines in hospitals, and all of the things that we need to promote socio-economic inclusion in our country.
Well, those are the views. She's also adding her voice to our discussion this evening, the former Public Protector, Tulima Tonsela. But now, an interesting thing is about the Nkandla report and her findings then, that the matter had to be taken to the courts to get Parliament to do or implement the remedies that she recommended. Was it necessary at the time to do that? Let me come back to you, Advocate.
Well, it was not necessary, you know, because as you know, in fact, there was a big debate that ensued thereafter as to whether a recommendation of the Public Protector is binding on the President, who had to implement the remedial action that she had recommended. I mean, we never should get to that stage in a constitutional democracy. As Dali had said, you know, the Constitution is the supreme law of the land. Yeah. We are out of the system of parliamentary superiority, which was the position before 1994. At that time, judges, and therefore the Constitution and the law, had to be subservient to what the legislature, you know, had prescribed. So it wasn't necessary for her to go to that extent.
But of course, I mean, the other parties took the matter to the courts, and you were very actively involved in that one as well. So I would like to hear your comments. That where did the parliamentarians then miss the point? I'm asking as just a member of civil society, that we would expect the lawmakers to understand this point much more than ordinary people in the streets.
No, Tim, I think we must separate two things. As we're both saying, the courts are there to adjudicate disputes. Any constitution of anything, not just of a country, is simply a framework. And ours is a very young democracy. So the constitution, what breathes lives into a constitution are disputes as they go along that nobody ever imagined. So to that extent, it's a good thing. But what Brady is saying is that there are certain disputes that we have had in the recent past, which were not really genuine disputes. Let me put it that way. Because the question of, for example, the status of the Public Protector's report, there's a view that that litigation was really being used as a delaying tactic for various other reasons, not because there's a genuine dispute, but to buy time. So and to that extent, then
one could say it was just politics. Really.
Absolutely. So that is what is wrong, to abuse a system that is genuinely there, which should be there to resolve and to breathe life into our constitution for various unbecoming reasons. So
and there are many more issues that we're going to raise. Stay with me on the Modise Network, and up next we'll be discussing the Truth and Reconciliation Commission and the legally complex land question, and there may be a link between the two, but we'll explore in a moment.